Proceed.
May it please the board, my name is Michelle Chemaine and I'm here representing Mr. Jerry Scarbrough. The rule of law is important. In fact, it is crucial. Not everything is always as it first appears, and our rules are designed to get to the truth, even when, in this case, the truth is not the obvious answer. Everyone, including persons brought before the disciplinary panel, is entitled to a full and fair hearing. I do not believe a full and fair hearing was given in this case.
Is that because of the collateral estoppel issue?
No, it's because of both the collateral estoppel and all of the evidentiary hearings, evidentiary rulings, and the inability to properly cross-examine both Mr. Ray and Ms. Tipton when they weren't telling the truth. Okay. First, I'd like to object to the novel composition of the statement of facts. Statements of facts should be made up of two things. One, the pleadings, with it obviously noted that you're quoting the pleadings, and two, evidence from the case. In this instance, most of the statement of facts is made up of quotes from the bankruptcy court's opinion. The bankruptcy court's opinion does not have the force of collateral estoppel. Only findings of fact, the jury verdict, and the judgment have collateral estoppel power. Therefore, they were improper, and in this case, they were highly prejudicial. Second, I'd like to address the motion for stay. Counsel for the commission spent ample time talking about the standard of review being substantial evidence. However, we're getting back again to what the rules say. The rules say preponderance of the evidence. It says, unless a respondent is disbarred, the conduct alleged allows the respondent to show by a preponderance of the evidence that he is not a danger to clients and the public. The counsel for the commission also argued...
Can I stop you there?
Yes.
Am I correct that Mr. Scarbrough has been serving his suspension actively at this point?
He has been. What I wish to do today in 3 seconds is to re-urge the motion for a stay from this time.
Beginning now and going forward for the remainder term?
Right. The unsavory allegations are not what determine whether he's going to be a danger to his clients or the public in the future. His sterling disciplinary record, where he has had not a complaint or a grievance or anything in 34 years, argues in favor of him not going out and being a danger. And the approximately 15 witnesses that he brought in that said that he would not be a danger, and in fact they were hurt by him not being able to continue to prosecute their cases in the case of client witnesses, is more relevant to this question, and therefore we are asking for you to look at the issue of a stay for the rest of the appellate process at this time.
Ms. Chemaine, isn't our standard of review on appeal on the stay an abuse of discretion standard?
No, I believe that because the authors decided to incorporate a standard of review directly in Rule 2.25, that you have the legal rule of the specific overriding the general, that
being the preponderance of the evidence?
Yes.
One could argue that preponderance of the evidence is the standard by which the evidentiary panel made its decision, and that our appellate standard is abuse of discretion. If we decided that abuse of discretion was the proper standard, what would your argument be to say that the panel abused its discretion in reaching and denying the stay?
There was virtually nothing in terms of the evidence presented at the motion for stay hearing that argued in favor of keeping him suspended. One lady from the bar testified. She testified that Mr. Scarbrough called her and said that he was not practicing. He said that he had orally informed all his clients. She informed him that he needed to do so in writing. And he was upset that the motion for stay hearing would not be had, before he was suspended. And she said she would get back to him on that issue. But he did not go on to practice. He waited to hear back from her. He respects the authority of the bar. He respects the authority of this panel. He has taken it all seriously. And I would say with the evidence,
Certainly, no problem.
with the evidence he presented, it would be an abuse of discretion not to grant him a stay. I thoroughly answered your question.
Yes, you have. Thank you.
In terms of the evidence, I recall that there were a number of people who testified in Mr. Scarborough's behalf, and my question would be, was the panel, the evidentiary panel that heard this, free to accept or reject all of it? And if so, where does that leave you?
I believe a magistrate or a panel or a board is always free to judge credibility. That leaves me with Mr. Scarborough's sterling record, the fact that all of these alleged disciplinary infractions were in one case, and the fact that Mr. Scarbrough has taken this all seriously.
Did he actually eventually write the letters required by the order?
I believe so. He didn't like it, but he did it.
Thank you.
He respects the authority. Okay. Third, as to special exceptions, this is something that you almost never bring up on appellate review. However, I still don't know what facts go with what disciplinary infraction. And that's a serious handicap when you are trying to defend a case like this. Petition should read that Mr. X did this, and those actions broke this rule. The particular rules that he is alleged to have broken are broad, they can overlap, and I was absolutely at a loss until Appley presented her brief as to what we were talking about. And that is truly a problem. It is harmful error. Collateral estoppel is, of course, a major issue in this case. Texas courts have traditionally been very cautious in applying offensive collateral estoppel, which is what we're applying here. The bar is not, but it should be. The Supreme Court has said that the Park Lane hosiery conditions must be looked at. It must be considered whether the offensive use of collateral estoppel may be unfair under the circumstances of the particular case. First and foremost, my personal experience. When I went to the Belton County Courthouse, I found that the entire courthouse was involved in a pool for money betting against Mr. Scarbrough on the trial. The pursers are very powerful people who usually get their way. I was appalled that this was what was going on amongst official court personnel.
Excuse me, are those facts anywhere in the record?
No, they are not.
Thank you.
It is also not in the record that my computer was again attacked this weekend, and I apologize, but I did not have access to any of the record, or until Mr. Scarbrough provided them to me, any of the briefs to prepare for this hearing. I'm sure that makes it harder in my presentation to you. Basically, under the incentive to vigorously defend, which is one of the things that must be considered to decide whether application is unfair under the circumstances of the particular case, Mr. Scarbrough had almost no incentive to vigorously defend anything in this trial. He had attorney immunity for all of the torts. Whether that was granted or not, he was going to have a good chance of getting it applied at the appellate level.
In that regard, what's the status of the appeal?
I don't know. I'm sitting and waiting. We have
Has it been argued?
We argued in October.
Of last year?
I believe it was October. Is that correct? September. Excuse me, September.
Of 2015.
And I have heard nothing since. I have presented the court with a letter giving them a new reference out of the Fifth Circuit on attorney privilege, saying that it's immunity from suit, not just immunity from damages. But of course, I wouldn't hear back on that. So I am as baffled as you may be. Okay.
You're suggesting that that offensive use of collateral estoppel is appropriate in a disciplinary proceeding. It's just that you feel it was unfairly or inappropriately adopted here. Is that your argument?
Actually, I believe that it will rarely apply to disciplinary proceedings because in a sanctions hearing, you typically have one judge ruling on the sanctions as opposed to 3 panel members, one of which in our case was board certified in appellate law. So you have procedural safeguards at the panel level that weren't available at trial. And you have a different risk. You have the risk of finite money judgments at sanctions for the most part. Whereas in the disciplinary matter, a man who has lived his entire career living and breathing the law and being an attorney honestly has his whole career at stake. And that's very frequently going to be a major difference in disciplinary matters. It is in this case, which is why I don't think collateral estoppel was fair, but I do go beyond that and say that in most cases it is not appropriate. And I do not believe that we are really cutting the work of the bar down by allowing collateral estoppel, because if evidentiary rulings are properly made, all evidence that bears on 2.18, the sanctions to be applied, should be able to get in at the panel level. So the length of the hearings should be approximately the same.
Ma'am, let me, I may be not accurate on this, but there were a number of charges that were the subject of either collateral estoppel or in which collateral estoppel was asked for but denied. But there were, at least by my count, at least a couple of them where collateral estoppel just was not involved, and there were findings on those. How do you respond to that? Let's just forget the collateral estoppel for right now.
I believe the other procedural errors caused an improper judgment on those, and those other procedural errors were not minor.
And are those the cross-examination?
And the credibility and the best evidence rule, where, for example, it was testified to that Mr. Scarbrough received repeated requests for the recorder. In fact, he did not receive a single request for the recorder until he had given it back to the client. We have Rule 1.196.4, that tells litigants how they should handle electronic media discovery, because a reasonably prudent lawyer isn't going to know everything he needs to know. And Mr. Ray simply did not follow that.
Let me ask you a question and follow up to that.
Yes.
For the violations that were not covered by offensive collateral estoppel, we're governed by a substantial evidence rule. Do you contend that there was not substantial evidence on those two violations, and if so, would you explain? Or are you saying that the process itself was so flawed that it permeates every finding?
I'm actually saying both. I made both objections in my brief, but you're going to have to refresh my memory. I apologize. This is partly due to the petition. Which rules were not subject to collateral estoppel? Which facts?
I would say probably Rule 3.03A.
Which was misrepresentation to a tribunal?
Yes.
Okay. In that case, there was absolutely no evidence presented to the panel that Mr. Scarbrough knew of other recordings, that he knew that you could get recordings off a recorder. And here I'm blurring things, but I'm not sure which one it was against. And the evidence was that his IT fellow testified in his behalf that he had not been given back the secret recording, so he didn't have it, and he didn't have control over it. The evidence was he couldn't get the recorder to work to be able to hear it, to ever know that he had it. And therefore, if you don't have knowledge, it's hard to make a knowing misrepresentation. It's impossible. And that's one example where both the collateral estoppel was a problem as far as the review for credibility and bias and best evidence, but also the facts just weren't there. No substantial evidence.
What about 804A3, which I think was a finding regarding the telephone call with the cousin or the niece?
Miss Bowling.
Yes, and I don't think that had collateral estoppel as part of its basis either. I understand, I read your argument that he realized immediately within 2 minutes that he had probably said something he shouldn't have, but the fact that she continued to talk with him and the panel apparently believed that she was misled, how do you respond to that?
I would say when she wasn't misled, because when he realized his mistake, he was very, very clear. I represent Miss Deaton. they're opposed to the pursers. I'm opposed to the pursers. There is no way that anyone who had their faculties could not know at that point.
But isn't that for the trier of fact? Didn't the panel have to believe Ms. Boulding as opposed to what your client said in order to?
I think some request to believe asked for us to suspend reality. And she talked to him when she knew who he was. Is that my signal that I'm done?
You're getting close. Let me see if any of the panel members have any questions.
I do have a question on that particular issue. You're saying that it's supported in the record that he came back and corrected his statement that he did not represent Mr. Purser Sr.?
Yes, every single time.
Can you cite me in the record where that's actually done, where he said he did not represent Mr. Purser Sr.?
Every single time that the bar quoted him, they left parts out. And what he said was he was opposed to all the pursers. And that's in the record, and I apologize, but my record was effectively stolen. And I didn't have the kind of prep that I would normally bring to a body of this importance.
Okay, because I certainly see in the record I think it's on page 146, where it indicates that he says that he represented Ms. Melissa Deaton, thank you. But I did not see in that same paragraph or in that same conversation that he came back and said that he did not represent Mr. Purser Sr.
I can't argue with you because I don't have the record in front of me, but it is my understanding that
We can
he
ask
did.
Ms. Hamilton. Anybody? Yes, Ms. Kinzer?
You made a statement about the evidentiary rulings being unfair, or I don't know if you used that word, but you did bring up the evidentiary rulings that were found against Mr. Scarbrough and that he did not have the opportunity to cross-examine some of the witnesses. Do you recall that?
Yes, I very much do.
Is there any
Credibility was the issue in this case.
Is there any place in the record where he preserved that evidence, either by bill of review or any type of...
There were a number of places in the chart that I put in my brief, and then Appellee's counsel said that she found the chart difficult to read, so I spelled it out in paragraph form in the reply brief. And again, I apologize. Having my record taken from me means I couldn't put the little notes in the margin of the expected questions.
So you believe in the record somewhere there's an offer of proof or a bill of exception with regard to these witnesses?
I believe that he preserved evidence because, looking at the case that I cited in my brief, sometimes a lengthy bill is not necessary. In the case of credibility, what you're saying is, I believe this witness is not telling the truth, and I want to give you an example where you will see that they're not telling the truth. So just raising credibility and explaining as he did in the record, saying he couldn't disprove credibility with one blow, that's not the exact wording, but that bit by bit he needed to ask a series of questions to hack away at, in this case it was Miss Tipton's credibility, to show that she lied even about minor things. Same with Mr. Ray. Mr. Ray testified that Mr. Scarbrough disturbed the funeral. That's a horrendous thing to do. And Mr. Scarbrough knew it was a horrendous thing to do. And not only did he not do it by not going anywhere near the funeral, he told the two girls not to go to the funeral. And that was one piece of a lack of credibility. But as he said when he was arguing credibility with Ms. Tipton's testimony, you have to do it bit by bit. But saying he's going...
Let me stop you right there. So what you're explaining to us is there was a fact question about whether or not Mr. Scarbrough disrupted the funeral, right?
According to Mr. Ray, there was a fact question.
All right. And so the way that you would defend against that would be bring in a witness that said, no, he didn't disrupt the funeral?
He wouldn't know who was at the funeral.
Okay. All right. Thank you.
Any other questions at this point for anyone?
My closing statement is just, if you do not buy the fact that these should be dismissed, please relook at the sanctions. I ask for them to be reduced to time served because this is a 67-year-old gentleman who has gone through an entire life with no blemishes. And he is devastated and definitely won't repeat these offenses.
Okay. Thank you very
Thank
much.
you for
You'll
your
have
time.
some rebuttal. Ms. Hamilton.
Good afternoon. May it please the board. The commission urges the board to affirm 4 of the 5 violations found by the panel because the record provides sound support for all of those 4 violations. And also because the procedural issues that Mr. Scarbrough has raised do not provide a basis for reversal.
Is it your position that we should affirm on all but the
3.04D.
right D, and it would just go back for another sanctions hearing?
That is correct. Well, actually, that the case should be remanded for a new trial on the 3.04D allegation and for a new sanctions hearing.
What would be the purpose of that if you already have these other findings?
Well, that's still a live allegation.
I understand, but I'm just trying to understand why you would want it that way as opposed to just going back and having a sanctions hearing.
Well, that appears to be the appropriate outcome based on the arguments that have been made in the appeal and our concession that the 3.04D collateral estoppel finding is erroneous and reversible. Once we get back to the evidentiary panel, then of course trial counsel for the commission can decide exactly how to proceed.
Let me just, the thing that troubles me to some extent is the collateral estoppel in this situation. I've never seen it used before in a disciplinary proceeding. Maybe that's because I don't get out often enough, but is this something the state bar regularly does, or is this a pretty unique situation?
Based on my experience handling appeals, it appears to be relatively unusual. There are some published cases, though, that are cited in the briefing, so this isn't the first time that the commission has used collateral estoppel, invoked collateral estoppel successfully against a respondent attorney, most notably the Goldstein case that's cited in the brief.
That was, what, 15 years ago?
Yes, correct.
I'm
That
just
is an
saying,
older
what is the
case.
practice of the CDC at this point? And
I think it is unusual. It is unusual, but in a case like this is an unusual case. We have 2 different decisions from 2 different courts on these same issues. So
you're talking about the bankruptcy court and the trial court?
that's correct, yes. A jury trial and then adversarial proceedings in the bankruptcy court. So there were already extensive proceedings on these same issues. So the idea that collateral estoppel would be appropriate in this case is not surprising.
If, for example, on 304, where you say we admit it wasn't appropriate, why should it go back as opposed to any other situation where you took your chance on the evidence, it wasn't sufficient, and it would be rendered at that point?
Well, there just really is no basis for a reverse and render because the commission did not try the 304D allegation in the evidentiary hearing, and that appears to be clear.
You didn't try it because you didn't think you needed to?
That's correct, because
So my question is, if you made that tactical decision, why should we give you another shot at it?
well, because the reversal of the collateral estoppel finding does not preclude trying that issue. It's the same as if the panel had denied the collateral estoppel motion on that issue, and then that doesn't mean the commission would be precluded then from trying the issue. But the proper outcome of the appeal on that issue is to reverse and remand for a new trial on that issue.
If we did remand, the phrase you used earlier is for further sanctions. Are you suggesting that the sentence could actually be increased?
Possibly, could it? Well, once that issue is tried, if there is some basis for increasing the sanction, then the panel would have the discretion to increase the sanction. Do we expect that the sanction would increase? No.
Well, if it can't be increased, then what's the point of remanding it?
So that the same sanction can be imposed, so that the commission can demonstrate that this violation that has been reversed was actually committed, and so the misconduct is the same. And in that case, the commission would likely argue for the same sanction, the imposition of the same sanction.
Part of what troubles me on the use of the offensive collateral estoppel in this is how broadly it was used on multiple instances. I feel like we are missing part of what compelled a very capable trial team to do it this way. On each of those points, there's actually ample evidence that could have been used by the commission in support of its position. Is there something we're missing from was the panel limited in terms of time? I know it went at least 2 days from review of the record. Is there some other reason why the use of it was so broad?
Well, that's not a question that I can answer. I have the same record that you have, and it's just not information that's in the record. It's not information that I have. Looking at the record, though, and trying to guess at the motivation for moving to have collateral estoppel invoked on, for example, the 304A issue, it really does make a lot of sense if you look at what was tried in the jury trial, the fact that this was a hotly contested, litigated issue, and the jury's findings, and specifically their question number 5 that was given to the jury, that answer incorporates all of the elements of 3.04A. So, and actually even goes beyond that. So it makes good sense that that issue does not need to be relitigated.
But does it really? 3 years later, we still have an appeal on that issue. And I recognize that we can provide collateral estoppel effect on the underlying verdict, but does it really make good sense if this could have been proved independently and found by the evidentiary panel? The fact that the appeal is still pending would be irrelevant.
That choice could have been made, yes, but it wasn't the choice that was made in this particular case. There is ample evidence in the record to support that 304A finding. Just the bankruptcy judgment and opinion standing alone provide ample support for that finding. So there is evidence in the record that was introduced at the hearing that would support that finding. So yes, you're right, that could have been the choice to handle it that way, and it looks almost certain that the commission would have been successful. But at the same time, collateral estoppel was chosen, I would guess, probably for the reason that other litigants choose to invoke collateral estoppel. And that is, the goal is to save resources.
Judicial efficiency.
Judicial efficiency. Not to mention, if you look at the witnesses involved in this case, they had been through a lot. Everybody involved in this case had really been through a lot. And so to bring all those same witnesses in again for another trial is also just the sources that go into that, the stress that goes into that for everyone involved. Can understand why a trial lawyer would make the decision instead to have these issues addressed in a more summary fashion once they have been litigated, not once but twice.
Let me flip this for just a second, ask you a question. If we found substantial evidence existed to support the evidentiary panel findings on several of the violations that were not subject to collateral estoppel, is that sufficient to uphold and affirm the sentence imposed?
So you're talking about the 3.03A1, I assume,
And
the
Rule 8.
804A3, those two findings. Would it be sufficient? The board probably has discretion to affirm and to affirm the sanction on that basis. Really, the question about whether a case gets remanded in a situation like that is whether further development of the record is needed, or for some reasons the interest of justice demand a remand. So I think that one would be a close call. When you are reversing a substantial part, if you reversed a substantial part of the judgment, I think it would be a close call as to whether it should be remanded. The board probably has discretion to make that call, but I think it would be a close call.
Thank you.
What we were talking about putting people through another trial, and I understand that, but how do you address it from Mr. Scarborough's standpoint? Obviously, he's lost his law license for up to 2 years, and then he's going to be on probation for a number of years after that. And that sort of dovetails into the materiality issue. In other words, what his counsel was saying, the incentive to defend one versus the other. How do you address those two issues?
Well, the incentive to defend, the stakes in the underlying litigation were very high for Mr. Scarbrough, both in the jury trial and then also in the bankruptcy adversary proceedings. So those stakes reached a level where he had an obvious, strong incentive to vigorously defend himself.
Is that incentive personal to him, or is that an objective standard? Because what may be important to one person may not be so important to the other. In other words, I don't care about a money judgment. I want to preserve my law license.
Yes, I think probably the board needs to look at that objectively, and just objectively, it does appear to provide adequate incentive. In addition to that, a lawyer with Mr. Scarborough's experience should foresee that the types of issues at play in those other proceedings could lead to disciplinary action. That was very unsurprising that after those proceedings and the findings that were made, the judgments that were entered against Mr. Scarbrough, that we ended up here is completely unsurprising. So it was foreseeable that this kind of, that disciplinary proceedings might result. So in addition to the fact that he had great incentive to just defend himself against those allegations for monetary reasons, in addition, he should have foreseen that disciplinary action might follow.
Well, was that the same as foreseeing that you were going to use collateral estoppel offensively? Should he have foreseen that?
Not necessarily. No, not necessarily.
But that's what's happened to him. Is that correct?
Correct. The commission has used collateral estoppel offensively. The commission's motion seeking to invoke collateral estoppel, though, is lengthy, goes into a lot of detail, and if we really just focus, if the board focuses on what we have left, which is just the 3.04A finding, the application of collateral estoppel to that jury decision is very clean and straightforward. The elements that the ultimate issues that the jury found include all of the elements of 3.04A.
So since it's on appeal, the civil trial matter, and let's say the appellate court finds in Mr. Scarborough's favor, what happens then if the collateral estoppel doesn't apply anymore, or does it not apply anymore? Because obviously he's already been sanctioned at this point. So if it goes on appeal, if the trial court or the appellate court finds in favor of Mr. Scarbrough, then what happens?
Well, this judgment right now is on appeal to the board, and we don't have a decision from the Court of Appeals at this point.
But assuming we were to affirm the findings that were had,
then this judgment would still stand.
So we should proceed as if the appeal, it doesn't even exist.
That's correct.
It's completely immaterial to any decision we make.
That's correct, and that is the reality that the Supreme Court has created. The Scarbrough decision discusses the reasons for that legal decision in detail. It was a similar situation. The court considered these kinds of issues in deciding that an appeal of a judgment doesn't matter. Once the judgment is entered, collateral estoppel applies.
Would the board be within its power to grant an exception to that rule?
No. The board has to decide consistently with what the Supreme Court has determined. Now,
But we determined whether offensive collateral estoppel is an appropriate remedy.
in a specific case, yes, consistent with legal principles that would govern that issue. And again, the 3.04a violation is a clean match with what was found and what he was collaterally estopped from disputing.
Is that alone enough to uphold this sanction?
The 3.04a finding, together with the 303a1 and the 804a3, yes, it is. The 304d finding is factually so similar to the 304a finding that they don't make a substantial difference in the seriousness of the misconduct. Mr. Scarborough's representations in court regarding the recordings and the absence of any additional recordings was egregious, but he had already passed a level of seriousness. His conduct had passed a level of seriousness before he ever even got to that hearing. So the conduct here is sufficiently egregious, even without the 304D finding, to support the sanction. The commission, though, has urged the board to remand this case, to reverse that 304D finding and remand the case. That appears to be...
At that point, if we did what you asked, what would be Mr. Scarborough's status? Would he be back
The sanction would not be...
So he would be free to practice law pending the outcome of the next hearing?
Yes. One other thing needs attention is just this question about the evidentiary rulings and their impact on this case. Now, as indicated in the commission's response brief, the chart that was provided by Mr. Scarbrough in his opening brief goes through 10 instances of supposed harmful and erroneous evidentiary rulings. But each one of those, the record that underlies each one of those 10 complaints really doesn't bear out the complaint. I went through every one of them in preparing for this argument. I, of course, didn't prepare the brief, but I went back through every one of them, and none of them actually are as they're described here.
Don't we have an abuse of discretion standard on that anyway?
That's correct. And the panel chair would have had broad discretion. And anyone who has read the transcripts of these hearings can see that this panel chair not only excluded evidence that Mr. Scarbrough offered and not only sustained the commission's objections, but did the opposite and sustained lots of Mr. Scarborough's objections and excluded evidence that the commission wanted to offer. This panel chair, it was clear, worked very hard to try to provide a fair hearing here. It was contentious, one of the more contentious hearings I've seen since I've been handling these appeals. But it was contentious from both sides, and the panel chair did a good job of maintaining fairness. She gave Mr. Scarbrough leeway several times throughout the record to continue with a questionable line of inquiry with witnesses.
Can an erroneous evidentiary ruling by a panel ever constitute reversible error?
It could, but it's rare. The exclusion of evidence rarely constitutes reversible error, and that's just because the burden is so high, and logically so. The party there has to be a record of what the evidence was, which in some cases here, we don't have a record of what the evidence actually was. We might get a vague idea, but that usually involves some guesswork. There also has to be error in the exclusion of the evidence. And because a panel chair has such broad discretion regarding the admission and exclusion of evidence, that's also very difficult to show. And then finally, probably the most difficult piece of the puzzle is that the party has to show that the judgment actually turned on that evidence, that it was so important that it caused an erroneous judgment to be entered. And so all three of those things have to be shown, and it makes it very difficult to obtain reversal because in most cases any one piece of evidence just isn't going to be the factor on which the judgment turns. And one quick thing about the stay. Yes, it is true that Mr. Scarbrough went a long way toward meeting his burden of proof to establish that he was entitled to a stay. But everything, his evidence, his witnesses really evaporated the moment that the record discloses that he was not in compliance with the judgment. He admitted that it was an intentional decision that he made not to send letters to his clients and not to inform courts of his suspension. And that fact, standing alone, justified the denial of his motion to stay.
Are you saying, but for that, there would have been error on the part of the panel in not granting the stay?
No, because really in any disciplinary case where we're looking at sanctions like this, and we're looking at misconduct like this, it's clear that the misconduct itself is very serious and rises to a high level of egregiousness. And so in a case like that, it might be impossible for a respondent to show that he does not pose a threat to his clients or to the public. And that's what he would have to show. So there may be cases where a respondent attorney just cannot rebut the presumption.
Do you know if Mr. Scarbrough eventually sent the letters? Do you know one way or the other?
I don't. I know that at the time of the hearing on the motion to stay, the testimony was that he did not.
And the standard for us on the stay?
On the stay is, well, it's a substantial evidence question, which is very similar to abuse of discretion. Really, there's no meaningful difference. So either one of those could be applicable. Questions about evidence, of course, that there only has to be more than a scintilla of evidence to support the decision.
Okay. Any other questions from anyone? Okay, thank you very much.
Thank you.
Two things I would like to address. First, on the collateral estoppel. It is very important to look at what is used for collateral estoppel. The only things that may be used are a judgment, a jury verdict, or findings of fact and conclusions of law. Case law says opinions are just an attempt by the judge to explain what he did, but they are not part of the judgment. Constantly, counsel for the commission refers to things in the bankruptcy opinion to collaterally estop.
Well, Ms. Shimeen, in fairness to the commission on 3.04A, 3.03, 3.04A, no, it's 3.03, I think. They are actually referring to jury findings, and that they say that that the preclusive effect should be applied there because there are actual jury findings that track it.
Those jury findings were whether he stole money from the pursers. That was the case presented for those jury findings. and to transform them into something else would simply be an injustice.
Yes, but you just said that findings of fact, those are findings of fact by the jury. I mean, they can be given, I'm not saying it's appropriate or inappropriate in a particular case, but they can be given preclusive effect. And that's not the bankruptcy opinion, that's the jury.
They can be given preclusive effect. I would say that it would be unfair in this case. As far as the sanctions, they were absorbed into the judgment. In other words, they were no more. Only what was in the judgment could be used. And the judgment did not comply with Civil Practice and Remedies Code, Section 10.005. It did not list out the factors that are required to support sanctions. Therefore, those sanctions cannot be used for collateral estoppel. It's pretty important. Also, at 3.04a, you must have the same ultimate issue in both the disciplinary proceeding and the trial. In one, it was whether he obstructed the other side's access to evidence. In the other, it was whether he was dishonest about discovery. Those aren't the same issues, because you could answer whether he'd obstructed their access with a resounding no. You can't use collateral estoppel in this case. As far as the evidentiary matters, while it is rare, it was harmful in this case. The error was keeping out questioning as to credibility, most importantly, and bias. This case was about credibility. You go in with Mr. Scarbrough saying, I have never had access to any other recordings. I wasn't asked about the recorder until I didn't have it anymore. I couldn't keep it from them. And you have Mr. Ray saying, with hearsay that was objected to and upheld, no personal knowledge, that Mr. Scarbrough indeed had these recordings and had access to the recorder. He gave no explanation how he had access if he couldn't push the button and work it. But this is what the case was about. And Mr. Scarbrough was indeed precluded from effective cross-examination. In depositions these days, we don't allow people to make detailed objections and argue them because it disrupts the whole flow and makes the cross-examination ineffective. Should be the same thinking here, even on the ones that he was allowed to reframe the question. And most of it was reframing as opposed to asking the same question. The whole flow of getting at the fact that they were not telling the truth was interrupted, and they were given time to formulate a palatable answer that wouldn't make them look like they were lying. And that absolutely decided the case.
That's your conclusion, correct?
That is, and that's all I have to say, except thank you for letting us be here.
Let me see if anybody has any questions. Thank you very much. We appreciate it. We will take this matter under advisement and advise you of our decision as soon as it's done. We are adjourned.